All right, property. Again, property is pretty broad. So you got to know joint tenancy, and you have to know how to sever a joint tenancy. It's not only on the essays, it's on the MBE. Make sure you at least pay some attention to rights among co-tenants and the concepts of accounting and contribution. I'm not going to go into detail on these. All right, now, rule against perpetuities. It's okay. Don't discuss the rule against perpetuities unless it's called. Adverse possession. If you have one fact that goes to any element of adverse possession is an issue, and you must discuss all of the elements. Let's say, for example, they say that the adverse possessor, they won't use the word adverse possessor, but the person occupying the land, say in a hostile way, in an open way, etc., was there for 30 years or 40 years. Well, that's a long time. I mean, the statute for perfecting adverse possession is probably going to be 20 years in most jurisdictions, 30 years at the most, anything over 30 years, and you're going to have a real adverse possession issue. Landlord-tenant, the duties of the landlord, the duties of the tenant, and then in particular, the defenses of the tenant. They have actually called, what are the tenant's defenses? And the answer is always the same. So you can look that up. They're in our proponics outline as well. Easements. Look, you got to know this rule. There's going to be an easement, and parcel A, parcel B, and let's say parcel A says to parcel B, I'll give you an easement. So there's express grant easement. And then parcel A gets sold. And the question is, does the new owner of parcel A, are they going to be subject to the easement? And here's your rule. Transfer of the survey and estate, that's parcel A, subjects the new owner to the easement unless parcel A is sold to a bona fide purchaser for value without any notice, where notice could be actual, inquiry, or record. And record notice or constructive notice, record/constructive, they mean the same thing, and they mean in the deed. And what frequently happens is there is no recordation. So the effective the failure to record, you don't lose your property, but if it gets sold off to a BFP, then you can lose it. All right, covenant theory. Remember that real covenants, the remedy is damage versus equitable servitudes, where the remedy is equitable. Let's say equitable servitudes, remedy is equitable. Real covenants, remedy is damages. For real covenants, you should definitely know the elements for the burden to run: intent, notice, touch of concern, and privity. And not only do you have to know this, it's my personal experience that most people's weakest area in property, you think, well, I don't know anything about property, but where you're really weak is on how these elements work. So I suggest you find a competent model and study the analysis for these. Equitable servitude, know the elements, and implied reciprocal negative easements, common grantor, common planner scheme, other restricted lots. Notice, know how to apply these. Land sales contract, basically during the pendency of the land sales contract, the doctrine of marketability, marketable title, says that the seller must deliver marketable title by the close of escrow. Now, at the close of escrow, one loses all of one's rights under the contract, and the rights under the contract are said to merge into the deed. Now, recently, actually a couple of times recently, the bar examiners tested this exception, fraud, which we've covered in other predictions. So just remember that where the land sales contract is procured by fraud, the doctrine of merger may not apply in the jurisdiction at hand. All right. But otherwise, when the doctrine of merger does apply, then you have to sue under the deed and the 6 covenants under the deed. And for a valid conveyance, basically you want to sue under the deed. You got to know the 6 covenants. And present delivery deeds, it's just save you some trouble here. There has to be a present delivery, but when that present delivery is found, then the deal is done. The deed has been delivered at that point, as soon as you find the present intent to deliver. All right. For the recording statutes, just on a notice jurisdiction, if you're in a notice jurisdiction, this is more MBE than anything else, but if you're in a notice jurisdiction, the last BFP wins. It's as simple as that. If you're in a race, and by the way, it's not the last BFP to record. Basically, it's the last BFP. So we have BFP number 1 fails to record, BFP number 2 fails to record, BFP number 3. These are, they happen sequentially. And BFP number 3 does not record, but he's the last BFP, or she's the last BFP. Now BFP 1 records and BFP 2 records. Who owns Blackacre? Answer, BFP number 3. The last, in a notice jurisdiction, the last BFP prevails. If that seems, counterintuitive, think about it. Think about it, because it's extremely important, and it's probably worth some MBE items, if not some serious points on the essays. No foreclosure. Foreclosure destroys the junior interests who get notice. They get destroyed. They go away. That's the big point. Now, with notice, so when they tested this before, it was some time ago, but when they tested it before, there was no notice, so the junior interest survived and got to sue the senior interest